The Caste Equity Legal Task Force is a national coalition of litigators, law professors, bar associations, legal advocates, and law school students committed to ending caste discrimination. We advocate for laws and policies that address caste discrimination to protect and support its victims. We provide resources, best practices, and continuing legal education credits to attorneys and other service providers working with victims of caste discrimination. The fight for caste equity is one of the most important civil rights movements of our time, and our mission is to win.
When we're asked questions about whether caste should be defined or the relationship between caste and law, we can simply go to other kinds of categories that we're more familiar with. So you can think about the question, does race have a strict definition under the law? Does the term woman have a strict definition under the law? And if you realize and you think about it that way, you can say that the things that a lot of the opponents of legislation that protects against caste discrimination, the arguments they make that if we accept them in the context of caste, then it really undermines the civil rights framework.
Clearly, there doesn't need to be a universally agreed upon definition of caste. I mean, in the same way as a universally agreed upon definition of sex, which is one of the definitions in both in the federal law as well as in California law. So how do you agree upon definition of sex?
The intersectionality of discrimination among immigrant communities goes beyond just skin color and nationality. And that's what's missing right now. The bigger question is, where do immigrant Americans fit in the context of Black and white America?
In a place where caste is not explicitly listed as a protected category, the first thing the defendant is likely going to do is the defendant is going to say, this isn't a valid claim.
The California Civil Rights Department against Cisco Systems is a perfect example of why the statute needs to include specifically a reference to caste. The department has brought its case alleging discrimination based on the categories that are available to it under the Fair Employment and Housing Act, which are race, national origin, religion, and ancestry, among others. But there's no specific mention of caste in the statute now. So the immediate response of Cisco was to say, well, we have to strike all these allegations of caste discrimination, throw them out, because the statute doesn't even cover that kind of discrimination. And if that were to happen, there would be no case left because the case really is about caste discrimination. So if it's not included under those other categories, which is the argument of Cisco and other employers and landlords and whoever might be engaging in that kind of discrimination will take that position in the future. If the statute does not specifically say caste discrimination is prohibited, that's going to be a stumbling block in any litigation enforcement action to try to deal with caste discrimination. That's why it's important to include it.
There are 18 classes that are protected in California law, 18, indicating the importance and the need for a clear identification of protected classes to be enshrined in anti-discrimination law. And until caste is explicitly added as a protected class, it will be very difficult for those who have been harmed to be able to have a remedy for discrimination.
There's really important value in explicitly identifying certain categories as protected under our discrimination laws, even if other categories already protect them. We already do this, for instance, with gender identity and sexual orientation claims. The Supreme Court has made clear in the Bostock case that sex discrimination encompasses gender identity claims and encompasses sexual orientation claims. That doesn't mean that it's not really important that our statutes explicitly ban gender identity discrimination and explicitly ban sexual orientation discrimination. These groups suffer from unique and distinct forms of discrimination that, while encompassed within broader sex discrimination manifest in specific ways for those groups. And it is important that our laws recognize and protect against those specific manifestations. Also, employers will know that they need to monitor their workplace to ensure that caste discrimination is not occurring, that they need to conduct trainings on caste discrimination, and they need to keep records of complaints of caste discrimination. Those are important practices for employers and for human resources departments to ensure that caste discrimination is not happening in the workplace. Those records also become very important in litigation if someone raises a claim of caste discrimination against their employer. All we're doing is making it clear in the statute itself that caste discrimination applies. So nothing is actually changing in terms of the standards that apply to caste discrimination. We're just making it clear in the law that there is no ambiguity at all that caste discrimination is covered. That is the benefit of clear signals in the law. That is the benefit of an explicit ban on caste discrimination.
In this country, we believe in equality. We believe people should not be subordinated. And if that needs clarification in the form of legislation to make everyone understand clearly that we don't allow caste in this country in any form, then I support that legislation. And for those who say that this legislation is either unnecessary or inconsistent with our laws in the United States, I say that that manifests a deep misunderstanding of what California is trying to do or should be attempting to do.
In India, you have seats saved for different people from different castes so that no one caste dominates.
You know, the U.S. actually rejected the concept of reservations back in 1978. So we never really had a quota system here or reservation system the way you have in India with fixed percentages. Here, once again, in higher education, it was primarily about taking account of race as one factor among many in the admissions process. But you couldn't do it in a mechanical way, and you couldn't have a particular number of seats that you were reserving. So the question is probably not really relevant for two reasons. One, Americans don't really have a reservation system. But secondly, to the extent that we deal with affirmative action and give special considerations for race, those have to be for groups that have a history of discrimination here in the U.S. and are underrepresented. There's only a few limited exceptions where we'll look at racial and ethnic groups. And one of those exceptions, probably the largest exception right now, is for admissions to colleges and universities. But they're the groups that would be considered and would receive special consideration have to be groups that are both underrepresented and with a history of discrimination in the United States. That is the kind of thing that had been sanctioned historically by the U.S. So those three groups tend to be Native Americans, Black or African Americans, and Hispanic Latinos or the Latinx community. There's not going to be any effort at all to expand this out to cover groups who have a history of discrimination in places other than the United States. So this is not going to lead in any possible way to reservations for anyone here in the U.S.
Caste discrimination is not exclusive of any religion, ethnicity, or geography.
Facially neutral can be defined probably best by contrasting it with something that is not facially neutral. And that would be a law that's directed at one particular racial or ethnic or gender group or whatever the group may be, and only applies to that group. So, for example, if the Civil Rights Act of 1964, the Federal Civil Rights Act, said that it was illegal to discriminate against African Americans, that would be directed only at that group. However, the Civil Rights Act of 1964, like all other anti-discrimination statutes that I'm aware of, is not framed that way. What it says is that it's illegal to discriminate on the basis of race. So it's not only unlawful to discriminate against African Americans, but also against whites or Latinos or Asians or any other group that might be classified as a racial group. This statute, SB 403, would not be targeted at any particular group in that way at all. In fact, there are caste systems in other parts of the world, and the bill recognizes that there are similar systems in South America, Asia, Africa, and that such systems are found across all communities of religious practice. So it's not focused at any particular religion or any particular racial or ethnic group or national origin group. This bill would make unlawful caste discrimination on the basis of caste by anyone against anyone.
From the perspective of a bar association like ours, bias and discrimination in general is unacceptable. I think the argument that this is targeting South Asians is an easy rhetoric that can be, provided by people. But at the same time, caste discrimination is not just in South Asia. I think this is a critical and crucial piece of legislation.
If you read the bill, you'll see that the word Hindu does not come up once in the bill. This bill has nothing to do with religion. It is a civil rights statute. It addresses the rights that people have in public spaces only. It doesn't touch upon any religious rights.
This is a civil rights issue. Saying Hindu communities or South Asians will be disproportionately affected is analogous to saying back in the day when there were anti-race discrimination laws passed, that white people would be disproportionately affected.
As a South Asian, as a Hindu, and as a person who is uncaste, there is a very small fringe vocal group of Hindus who are trying to tell me what my Hinduism is. And they're attacking people who represent my version of Hinduism, or at least my spirituality and my sense of community. Allowing a fringe to dictate the interests and the wishes of the majority, I feel really proud when I see fellow South Asian Americans coming out and asserting their own sense of Hinduism. I really hope that at the end of the day, we see reason in all of this.
Under the proposed bill, caste discrimination will be incorporated into present civil rights and anti-discrimination statutes. That means that all of the standards of proof that apply in other discrimination claims will port over directly into a caste discrimination claim. So, for example, if someone is claiming that they suffered caste discrimination in employment, that they suffered an adverse employment action, such as a termination, a demotion, a denial of equal pay because of their caste, and they only have circumstantial evidence to support that, they will, after discovery, have to show that they meet what's called the prima facie case of discrimination. That means that they're going to have to show that they're the member of a protected class, that they were qualified for their position, and that they suffered an adverse employment action under circumstances that suggest a discriminatory motive. Once they meet that prima facie case, the employer would have an opportunity to rebut it with evidence that the employer had some legitimate or purportedly legitimate reason for taking the adverse action that it took. At that point, the plaintiff would then have to show that, in fact, the employer's reasons are a pretext for actual caste discrimination, or that the circumstances in general make clear that caste was a factor motivating the decision to take the adverse action against the worker. All of that to say is there are well-established burdens of production, burdens of persuasion, and burdens of proof in all discrimination cases that would apply in a discrimination claim based on caste as well.
It's important for us as a bar association that represents the South Asian diaspora in the United States and Canada to kind of push for ending discrimination based on caste or perceived caste. If you can't take a stand as a South Asian bar association, I'm not sure who else could take that stand.
Caste discrimination, like race discrimination, still goes on today in the U.S., and just ignoring it, I think, is not an acceptable solution when there are steps we can take to protect its victims.